The table was full. Laughter was normal. Nothing looked like the last dinner of my marriage. If someone had asked me that evening how my life was going, I would have answered without hesitation that it was steady. 10 years of marriage has a way of settling into something quieter than passion, but stronger than doubt. We weren't dramatic. We weren't volatile. We were predictable in the way people become when they believe they've already survived the hardest parts together. That belief shaped everything I felt that night. The dinner wasn't special. That's what made it honest. Family gathered around the table, plates passed back and forth, familiar jokes recycled without effort. The room felt warm, not just because of the food, but because of history. 10 years creates shared language. Glances that replace words, routines that don't need discussion. I sat there relaxed, leaning back in my chair, listening more than talking, completely at ease in a life I thought I understood. My wife sat beside me, confident and composed. She looked comfortable in the role she'd perfected over the years, engaged, present, exactly where she was supposed to be. She laughed at the right moments, added to conversations effortlessly, her body language open and relaxed. There was nothing in her expression that suggested distance or distraction. If anything, she seemed lighter than usual, almost relieved. Trust wasn't something I was actively thinking about. It was just there, like the table beneath my arms or the sound of voices around me. 10 years had trained me not to question ordinary moments. We had routines that worked, habits that felt earned. No secretiveness, no sudden changes, no warning signs people talk about when they explain betrayal in hindsight. That night felt like proof that stability existed. I remember thinking how rare it is for families to sit together without tension. No arguments, no awkward pauses, just noise, warmth, and comfort. I didn't feel the need to check my phone or scan the room. My mind wasn't searching for cracks because I believed there weren't any. Loyalty, to me, wasn't fragile. It was assumed. My wife caught my eye at one point and smiled. Not performative, not forced. Familiar. The kind of smile that comes from shared history, from knowing someone has your back. I smiled back without thinking, unaware that this moment would later replay in my mind with a weight it didn't carry then. Dinner moved along naturally. Plates emptied, glasses refilled. Conversations overlapped. Nothing slowed down. Nothing felt off. That's the part people don't understand about betrayal. It doesn't announce itself with tension. It hides inside normalcy. It waits until you're relaxed enough to stop paying attention. I leaned forward slightly to reach for something on the table when a sound cut through the room. Not loud. Not dramatic. Just a vibration against wood. A phone buzzing. At first I didn't register it as important. Phones buzz all the time. But then it buzzed again and again. My wife's phone, resting face down near her plate, vibrated insistently, breaking the rhythm of the evening. She moved quickly, a little too quickly, flipping it over and silencing it with practiced ease. She laughed it off, making a casual comment about notifications, brushing it away like it meant nothing. Everyone moved on. Everyone except me. Not because I was suspicious, but because for the first time that night, something didn't belong. The table was still full. The laughter returned, but my attention stayed fixed on that phone, sitting quietly now, as if it hadn't just interrupted 10 years of trust. And for reasons I couldn't yet explain, I knew that whatever had just tried to reach her wasn't meant for this table, or for me. When I finally met Linda Harrington, she smiled like a neighbor, but spoke like a threat. I walked into my first HOA meeting, believing calm would solve everything. I had prepared documents, payment records, and a reasonable explanation. 10 years of home ownership had taught me that most disputes came from misunderstanding, not malice. I expected discussion, maybe mild disagreement, but ultimately resolution. That belief followed me into the room, right up until Linda Harrington introduced herself. She didn't rush. She didn't raise her voice. She stood at the front of the table with a polished confidence that felt rehearsed, like someone who had practiced authority in front of a mirror. She smiled warmly as she said her name, emphasizing her role as HOA president, as if the title itself carried weight beyond explanation. Everything about her appearance suggested order: neatly arranged papers, controlled posture, eyes that measured before they acknowledged. When it was my turn to speak, I explained the issue calmly. A disputed fee, a notice that didn't match my records. I wasn't accusing anyone. I was asking for clarification. Linda listened with a patient expression that didn't quite reach her eyes. When I finished, she tilted her head slightly and responded with a tone that sounded courteous but landed sharp. She dismissed my concern without addressing it directly. She spoke in generalities, referencing policy and procedure, never specifics. When I asked for documentation proving the debt was valid, she smiled again and said it wasn't necessary. According to her, the system had already decided. The amount was correct because the HOA said it was. Evidence, she implied, was a privilege, not a right. I glanced around the table, expecting someone to interject. Other board members sat stiffly, eyes down, hands folded. No one challenged her. No one supported me. Their silence felt practiced, like people who had learned the cost of speaking up. That silence told me more than Linda's words ever could. She didn't just lead this room, she controlled it. As she spoke, I noticed how the paperwork flowed through her hands. She referenced files without showing them, cited rules without quoting them. Everything passed through her authority first. The HOA wasn't presented as a group of neighbors managing shared space. She framed it as an institution, immutable, final. The HOA is the law, she said casually, like it was a favor she was reminding me of, not a warning. That was the moment my discomfort sharpened. Communities are built on cooperation. Laws are enforced through power. Linda wasn't interested in resolving a dispute. She was interested in maintaining control. The debt wasn't a misunderstanding to her. It was leverage, and she wielded it with a calm that felt deliberate. I tried once more, asking what my options were if I disagreed. Her answer came too quickly. There were appeals, she said, but they required time, fees, and compliance. The way she listed them made it clear they weren't designed to help homeowners. They were designed to exhaust them. Her smile never faded, but something predatory moved beneath it, like she was already anticipating the outcome. When the meeting ended, she thanked everyone pleasantly and gathered her papers with precise movements. I left the room with my documents still neatly stacked, completely untouched. Nothing had been resolved, but something had been revealed. Outside, the air felt different, heavier. I replayed her words, her tone, the silence of the board. I realized I hadn't attended a meeting. I had been assessed, measured, categorized. Linda Harrington hadn't needed to raise her voice or threaten me directly. She didn't have to. What I didn't know then was that the decision had already been made. The debt wasn't the issue. My house was. $143. That's all it took to put my family's future on the chopping block. At first, the number almost felt insulting in its simplicity. $143 wasn't a crisis. It wasn't even an argument. It was the kind of amount people miscalculate, forget, or resolve with a single phone call. That's what I believed when I first saw it listed as an outstanding balance. I assumed there had been a mistake, a missed payment, or a clerical error that would be corrected once someone actually looked at the records. Instead, the number began to grow. Not dramatically at first. A late fee here, an administrative charge there. None of it clearly explained, none of it tied to an invoice I could verify. Notices arrived without itemized breakdowns, only totals that changed just enough each time to make questioning them exhausting. When I asked for documentation, I was told it had already been sent. When I asked when, I was told it didn't matter. Communication shifted quickly. Emails stopped sounding conversational and started sounding rehearsed. Phrases like community standards and account delinquency replaced basic explanations. Then the certified letters began arriving. Thick envelopes, official seals, language designed to intimidate rather than inform. Each one escalated the tone. warning of consequences without ever clarifying the original charge. What unsettled me most wasn't the money. It was the speed. The urgency felt manufactured, as if pressure itself was the goal. Deadlines shortened, penalties stacked. I was no longer being asked to resolve an issue. I was being positioned as a problem. Legal language crept in where neighborly communication once lived. References to statutes, mentions of enforcement authority. The HOA stopped presenting itself as a group of residents managing shared space and started acting like a governing body with punitive reach. It wasn't collaborative, it was procedural. And procedures, I learned, can be weaponized. That's when I discovered something no homeowner ever expects to learn too late. The HOA didn't need a judge to act. They didn't need a hearing. They could place a lien on my home without court approval, without my consent, and without proving their case to anyone but themselves. A process designed for efficiency had become a tool for coercion. Linda understood this better than anyone. She hid behind complexity, knowing most homeowners don't have the time or energy to decode bylaws written to discourage scrutiny. Every question I asked was answered with another reference, another subsection, another step that required fees to access. Confusion wasn't accidental. It was strategic. I tried to pay the amount under protest just to stop the escalation. That's when the final shift happened. My payment was rejected. Not because it was incorrect, but because it didn't include newly added charges I had never been notified about. Charges that appeared only after I attempted to resolve the issue. It became clear then that the debt was no longer the objective. The balance was leverage. The longer it remained unresolved, the more power it gave her. It justified letters, threats, and legal posture. It created a paper trail that framed me as non-compliant, regardless of my efforts. Paying it would end the leverage. Keeping it alive preserved it. I stopped seeing this as a dispute over money and started seeing it for what it was. A test. A way to see how far she could push before I broke or backed down. The amount didn't matter anymore. What mattered was control. Then one afternoon, another certified letter arrived. This one felt different. Heavier. Final. I opened it slowly, already sensing the shift in tone before I read a single word. That's when I saw it. The lien notice. And in that moment, I understood that the fight was no longer about a balance. It was about my home. Seeing my home listed with a lien felt like watching someone else claim my life's work. I stared at the document longer than I should have, reading the same lines again and again as if repetition might soften their meaning. My address, my name, a legal mark placed against the house I had worked for, planned for, and built my family inside. The lien wasn't loud or dramatic. It was quiet, clinical, and devastating in its simplicity. With a few typed paragraphs, something that had always felt permanent suddenly felt conditional. The emotional weight hit first. Not panic. Heavier than that. A slow pressure in my chest as I realized what this meant. This wasn't a warning anymore. It was a claim. A statement that my home, the symbol of stability I believed I had earned, was now leverage in someone else's hands. Refinancing became impossible. Selling became complicated. Ownership itself felt fragile in a way I had never experienced. I reached out to Linda immediately, believing, briefly, that this was the moment conversation would finally happen. That assumption evaporated quickly. She didn't deny the lien. She didn't explain it either. She spoke with the same controlled tone she had used in the meeting, repeating policy language and reminding me that enforcement actions were procedural. When I asked how to resolve it, she deflected. When I asked what steps were required, she referred me to the HOA's attorney. That was when the word foreclosure entered the conversation. Not hinted, not implied, stated. Over a sum that barely registered as a monthly expense, the HOA was prepared to initiate foreclosure proceedings. The realization landed hard. This wasn't about compliance or fairness. No rational system threatens to take a family's home over a technical balance unless something else is driving it. Control had replaced logic entirely. At home, the tension became visible. My wife tried to stay calm, but I could see the fear she was working to suppress. Conversations lowered. Decisions became cautious. The kids didn't understand the details, but they sensed the shift immediately. Children always do. They notice when safety feels uncertain, even if no one says the word out loud. The HOA's attorney contacted me soon after. The tone was different, formal, distant, shielded by legal language. There was no interest in discussion, only deadlines. No acknowledgement of dispute, only reference to authority. Every email reminded me that process mattered more than people, that procedures, once set in motion, don't slow down for reason. That was when my faith in the system began to crack. I had grown up believing that ownership meant security, that laws existed to protect fairness, not exploit it. But here I was, watching a framework designed for community management turn into a mechanism for dispossession. No judge had reviewed the facts. No neutral party had weighed reason. The system trusted itself completely. I realized something unsettling then. The lien wasn't just pressure, it was precedent. If this worked, it could work again. On anyone. Compliance wasn't the goal. Submission was. And Linda knew exactly how far she could push before resistance became impossible. Time started to feel different. Shorter. Every day carried weight. Every envelope felt dangerous. I wasn't just defending my home anymore. I was racing against a process designed to outlast me. When the next letter arrived, it didn't surprise me. I already knew where this was heading. The language inside was colder, more final. A sequence, not a suggestion. Foreclosure papers were next. And suddenly, the dream I had trusted for years was hanging on deadlines I didn't control, and time I was quickly running out of. They didn't need force. Fear did the job just fine. Fear doesn't arrive all at once. It seeps in quietly, settling into the spaces where certainty used to live. For me, it showed up at night first. Sleepless hours spent replaying conversations, rereading emails, calculating numbers that refused to stay small. Every deadline felt closer than the last. Every silence from the HOA louder than a threat. The strain wasn't just financial anymore. It was psychological. The bills didn't stop. Legal consultations weren't cheap. Each question came with a warning. Each answer wrapped in caution. The HOA understood this balance perfectly. They weaponized time. Notices arrived with just enough urgency to keep me off balance, but never enough clarity to resolve anything. When I responded, they went quiet. Silence became strategy. It forced me to imagine worst-case outcomes on their behalf. Around the neighborhood, something shifted. People who once waved now looked away. Conversations ended quickly. Doors closed sooner than usual. It didn't take long to understand why. Word travels fast in places governed by fear. Everyone knew what was happening to me, and everyone knew what could happen to them. My situation became a warning without ever being announced. Linda's reputation filled in the gaps. Stories circulated quietly. Homes forced into foreclosure. Disputes that ended badly for homeowners who pushed back. She was described as efficient, relentless, someone who always won. That word, won, kept coming up, as if this were a game with predictable outcomes and I had already been placed on the losing side. I consulted attorneys hoping for reassurance. Instead, I got realism. HOA law, they explained, overwhelmingly favors associations. Boards are granted wide authority. Courts defer to procedure more than fairness. Fighting back was possible, but uphill, expensive, and slow. They didn't tell me I couldn't win. They told me what it would cost to try. That cost wasn't just money. It was time away from my family, emotional energy drained into documents and deadlines, nights spent preparing for battles I didn't ask for. More than once I considered giving in, paying whatever they demanded, signing whatever they wanted, walking away from the house just to protect my family from the constant tension. That thought scared me more than foreclosure ever could. Because giving up wouldn't end the fear, it would validate it. It would confirm that intimidation works, That power goes unchecked when people get tired enough. I realized that was what the HOA relied on most. Not law, not reason, exhaustion. They didn't have to be right. They just had to outlast you. Still, doubt crept in. I questioned my instincts. Wondered if I was being stubborn instead of smart. The system was clearly stacked. The pressure was real. And Linda knew exactly how far to push without crossing a line that would attract scrutiny. Fear had become her most reliable enforcement tool. But something about the whole situation refused to settle. The more I replayed events, the more patterns emerged. The speed of escalation, the refusal to document, the blocked payment, the insistence on foreclosure over resolution. It didn't feel like policy enforcement anymore. It felt personal, strategic, deliberate. I realized then that I'd been reacting this entire time, responding to deadlines, answering threats, chasing explanations that never came. Fear keeps you reactive. It narrows your vision. And that's exactly where they wanted me. That night, instead of drafting another response or calculating another worst-case scenario, I did something different. I stopped responding altogether. I pulled out every document, every bylaw, every public record I could find, not to defend myself, but to understand them. Because if fear was their weapon, information would be mine. And that was the moment everything began to change. Buried in county records was the mistake that would expose everything. Once I stopped reacting, the noise faded. Deadlines lost their grip. Threats blurred into background static. What remained was a single question I hadn't asked before. Not what the HOA was doing, but how they were doing it. That shift changed everything. Instead of defending myself, I started studying the system Linda relied on so confidently. I began with public records, county filings, property records, HOA registrations. What started as casual searching quickly became obsessive. Late nights turned into early mornings as I traced documents backward, cross-referencing dates, names, and signatures. The more I read, the clearer one thing became. HOA power looks absolute only when no one checks the paperwork. Liens, I learned, weren't casual actions. They followed strict procedures. Notices had to be sent in specific ways. Waiting periods mattered. Authorization wasn't optional. It had to come from the board, documented and recorded properly. The system assumed compliance because most people never looked closely enough to challenge it. That assumption was Linda's weakness. As I dug deeper, inconsistencies started surfacing. Small at first, a date that didn't align with a notice, a signature that appeared before a meeting supposedly took place, filing timestamps that contradicted the timeline outlined in their own letters. Each discrepancy alone could be explained away. Together, they formed a pattern. The more I compared documents, the more one name kept appearing where it shouldn't have. Linda's. Not as a representative, not as a witness, but as the sole authorizing signature on filings that required board approval. According to the bylaws, she didn't have that authority. The board did, and yet, the paperwork suggested she had acted alone. One detail stopped me cold. A mandatory step, one required by state statute, had been skipped entirely. No proof of notice, no confirmation of compliance. The lien had been filed as if procedure were optional, as if no one would ever question it. For the first time in weeks, I felt something other than pressure. Hope surfaced, but carefully. I didn't let myself celebrate. Suspicion wasn't enough. Hope without proof is just another form of vulnerability. I needed something undeniable, something that wouldn't dissolve under scrutiny. I slowed down then, reread everything, verified sources, checked originals instead of summaries. I didn't want a theory. I wanted certainty. Linda had built her power on the assumption that homeowners wouldn't look past the surface, that they wouldn't understand the language, that they'd surrender before discovering the cracks. What unsettled me most was how deliberate it all felt. These weren't clerical errors. They were shortcuts, decisions made with confidence, backed by the belief that fear would cover any procedural sins. Linda hadn't just enforced the rules. she had bent them, trusting intimidation to keep anyone from noticing. As dawn crept in through the window one morning, I sat staring at a single document pulled from the county's database. It didn't look dramatic. No bold warnings, no threatening language. Just a form, ordinary, administrative, and devastating in its implications. It proved the lien's timeline didn't match the HOA's claims. It showed the filing preceded proper authorization. It connected every inconsistency into one undeniable conclusion. The lien might not just be aggressive, it might be invalid. I leaned back, letting that settle, not as relief, but as responsibility. If I was right, this wasn't just about saving my home anymore. It was about exposing a system that relied on people never checking its work. But proof changes power dynamics, and I knew once I used it, there would be no going back. Because that one document, the one Linda never expected anyone to find, didn't just challenge the lien. It challenged everything she'd built. That single record wasn't just evidence. It was a confession. The more I reviewed the document from the county records, the more it pointed outward instead of inward. It wasn't just about my lien anymore. It referenced a case number I didn't recognize, a settlement filed years earlier, buried deep enough that it wouldn't surface unless someone knew exactly what to look for. That alone felt intentional. Settlements don't disappear by accident. They get buried when someone is counting on time to erase memory. I pulled the case file and read it slowly, carefully. It involved the HOA. It involved enforcement authority. And it involved Linda Harrington by name. The language was precise, unmistakable. Years ago, the HOA had been sued over abusive lien practices. The case never went to trial because it ended in a settlement, one that imposed clear limits on how and when liens could be filed. Board oversight was mandatory. Additional disclosures were required. Foreclosure actions were restricted without documented compliance. None of that had been followed in my case. What made my stomach drop was realizing this settlement wasn't obscure. It was binding. It applied to every homeowner in the association, and yet it had never been disclosed. Not in welcome packets, not in annual meetings, not in any of the communications Linda relied on to assert authority. The power she wielded so confidently came with conditions she never mentioned, because mentioning them would weaken her. The foreclosure attempt wasn't just aggressive. It violated the agreement outright. I took everything to my attorney, expecting cautious optimism. What I got instead was silence, followed by a slow exhale. He leaned back in his chair and told me this wasn't just helpful. It was explosive. Settlements like this aren't suggestions. They're enforceable. Violating one doesn't just undermine a lien. It exposes the entire organization to sanctions, penalties, and renewed litigation. For the first time since this began, the balance shifted visibly. The HOA's authority, once absolute, suddenly looked brittle. Their threats depended on a version of reality where no one remembered or discovered that they had already been reined in once before. Fear works best when history is hidden. Linda's confidence started to crack almost immediately after my attorney sent notice. The tone of correspondence changed. Deadlines softened. Language that once sounded final became conditional. Requests replaced demands. It wasn't subtle. People who rely on intimidation rarely adjust gracefully when it stops working. They were on defense now. What struck me most was how quickly control dissolved once the right information surfaced. The same system that had felt impenetrable weeks earlier now seemed fragile, overextended, and exposed. Authority doesn't vanish when challenged. It vanishes when it's revealed to be conditional. But there was a cost to exposing it. This wasn't something that could be resolved quietly anymore. The settlement wasn't a technicality. It was a line in the sand, and crossing it had consequences. Using it meant escalation, formal filings, court appearances, public scrutiny. It meant standing across from them openly instead of navigating around them in silence. I didn't take that decision lightly. Court isn't just about truth. It's about endurance. And while I finally had leverage, leverage only matters if you're willing to use it fully. There would be no half measures from this point on. No more back-channel resolutions or polite requests. This would be direct, on record, unavoidable. I thought about my family, about the months of pressure, the fear that had seeped into our home, about how close I'd come to giving up simply to make it stop. And I realized something important. Avoiding conflict doesn't prevent damage when the system itself is abusive. It only delays it. Exposing this meant taking them head on. And once I did, there would be no going back. Because that single legal record didn't just collapse their scheme, it forced a confrontation they had spent years ensuring no one would ever attempt. Walking into that courtroom, I knew this was bigger than my house. The air inside felt heavier than any room I'd been in before. Not because of drama, but because of consequence. This wasn't a place for intimidation or posturing. Every word spoken here would be recorded, weighed, and preserved. For months, Linda Harrington had thrived in spaces where authority went unquestioned. This wasn't one of those spaces. She sat at the table across from us, posture straight, expression controlled. The confidence was still there, but it felt rehearsed now, like muscle memory struggling to adapt to resistance. When she testified, she spoke the same way she always had. Polished, assured, framed as someone simply doing her job. She referenced procedures, responsibilities, and community standards as if repetition could restore the authority she'd lost. But the courtroom wasn't interested in tone. It was interested in facts. The judge listened without interruption, eyes moving between documents and testimony with methodical patience. When the legal record was introduced, the settlement, the filings, the skipped steps, the room shifted. This wasn't abstract anymore. Dates were read aloud. Signatures were examined. The narrative Linda had relied on for years began to fracture under scrutiny. The HOA's attorney tried to regain footing, offering explanations that sounded confident until they were tested. Each answer created another question. Why wasn't the settlement disclosed? Why were required notices missing? Who authorized the lien, and when? The more he spoke, the less stable the foundation appeared. Procedure, once their shield, became the lens that exposed them. Questions began to stack, not dramatically, but relentlessly. The judge didn't accuse. He clarified. He asked for confirmation. He asked again when answers didn't align. The process itself did what fear never could. It stripped power of its performance and left only compliance behind. I watched as Linda's certainty thinned. Not visibly, not emotionally, but structurally. Her testimony relied on assumptions the record no longer supported. Each reference to authority collided with evidence that authority had limits. For the first time, she wasn't directing the room. She was responding to it. Then the lien itself came under examination. The timeline didn't hold. The authorization didn't exist where it was supposed to. The required steps hadn't been followed. What had once felt inevitable unraveled piece by piece, not with confrontation, but with clarity. The foreclosure attempt, framed as enforcement, now looked like overreach, one with consequences. When the judge spoke again, his words were measured and precise. He acknowledged the seriousness of foreclosure actions and the responsibility that comes with wielding them. He noted the settlement. He noted the omissions. And then he did something that months of pressure hadn't prepared Linda for. He halted the foreclosure. The words landed quietly, but their impact was immediate. The threat that had loomed over my family for months evaporated in a single ruling. No raised voices, no dramatics, just accountability applied exactly where it belonged. Silence filled the room. It wasn't relief I felt first. It was disbelief, not because justice had been done, but because it had taken this much to force it. The system hadn't failed. It had waited. And once engaged fully, it had worked with precision. I glanced at my attorney, who nodded once, subtly. This was only part of it. The lien was halted. The foreclosure stopped. But the record was still open. The violations hadn't vanished with that ruling. As the judge gathered his notes, he paused, not as someone concluding, but as someone preparing to continue. His expression didn't suggest finality. It suggested unfinished business. I realized then that this wasn't the end of the story. Not yet. Because while the immediate danger had been neutralized, the actions that led here still demanded an answer. And the judge wasn't finished yet. Watching their power crumble felt unreal. The shift didn't come with shouting or spectacle. It came with language, measured, deliberate, impossible to ignore. The judge addressed the HOA directly, not as a community organization acting in good faith, but as an entity that had overstepped its authority. His tone wasn't angry, it was disappointed, and that, I learned, carries far more weight. He began by reprimanding the HOA for its handling of enforcement actions, not vaguely, specifically. He referenced the skipped procedures, the missing disclosures, the reliance on threats instead of compliance. Each point landed cleanly, backed by the record they had assumed no one would ever read closely. This wasn't interpretation anymore. It was correction. Then came the sentence that changed everything. The lien was declared invalid. No qualifiers, no delays. The legal claim they had used to control me, intimidate my family, and threaten foreclosure was stripped of legitimacy in open court. Months of fear collapsed in seconds. What had felt immovable was revealed to be built on shortcuts and assumptions. The judge didn't stop there. He questioned the fees layered onto the original balance, how they were calculated when they were added, and whether they were permissible at all. The numbers that had grown without explanation were suddenly exposed to scrutiny. Charges that had been treated as untouchable were now suspect. Procedure mattered now, and the HOA no longer dictated how it would be interpreted. Linda sat silently as this unfolded. The confidence she once wore effortlessly couldn't survive daylight. Her credibility took visible damage, not because she was attacked, but because the record contradicted her. Authority doesn't collapse when challenged emotionally. It collapses when it's proven inaccurate. What struck me most was who else was in the room. Other homeowners had come, some out of curiosity, some because they recognized the pattern. They listened closely as the judge spoke, taking in every detail they'd never been told. For the first time, they weren't hearing HOA power described abstractly. They were watching its limits enforced in real time. A precedent was being set, and everyone could feel it. This wasn't just about my case anymore. The ruling established that enforcement without compliance wouldn't stand, that secrecy wouldn't be tolerated, that intimidation wouldn't substitute for authority. Fear, once the HOA's strongest tool, began to loosen its grip as clarity took its place. Outside the courtroom, conversation started immediately. Quiet at first, then steadier. People asked questions they'd been afraid to ask before, compared notices, reconsidered past disputes they'd written off as unwinnable. The truth doesn't spread loudly. It spreads persistently. I realized then how isolated fear keeps people. Each homeowner had believed they were alone, uniquely targeted, powerless. What the court had done was connect the dots publicly. It turned private anxiety into shared understanding. And shared understanding weakens control. Linda didn't look at anyone as she gathered her papers. She didn't need to. Her authority had already been reframed, not as absolute, but as conditional. The image she had cultivated for years cracked in a single session, not because she lost composure, but because she lost credibility. As we left the courtroom, the atmosphere felt different, lighter, not triumphant, resolved. Justice doesn't celebrate, it clarifies, and clarity had arrived. But I knew this wasn't the end. Invalidating the lien addressed the immediate harm. Questioning the fees exposed the mechanism. Damaging credibility shifted perception. Yet none of that addressed accountability for what had already been done. The months of pressure, the abuse of process, the quiet reliance on fear to force submission. The truth was out. The precedent set. The power balance changed, but consequences were still coming. Justice didn't stop at my front door. What happened in that courtroom didn't stay contained within its walls. It moved outward, quietly at first, then with momentum no one could slow down. The ruling gave homeowners something they hadn't had in years. Not courage, but permission. Permission to question. Permission to demand answers. Permission to stop accepting fear as the cost of living in their own homes. Within days, conversations turned into action. Homeowners began requesting audits of HOA finances and enforcement practices. Not casually, not individually, but collectively. They wanted to see where fees were coming from, how liens were authorized, and why so much authority had been concentrated in so few hands. What had once been dismissed as paranoia was now framed as due diligence. Complaints followed quickly. State regulators received formal filings outlining patterns of abuse, citing the court's findings as proof that this wasn't an isolated dispute. The same procedures Linda had relied on to silence dissent were now being dissected publicly. Emails and records that once intimidated homeowners became evidence of systemic overreach. Inside the HOA, pressure mounted. Emergency meetings were called. Agendas changed. The atmosphere shifted from control to damage management. Motions were introduced questioning leadership decisions, then leadership itself. For the first time, Linda wasn't the one directing outcomes. She was defending her position. Votes for her removal surfaced sooner than anyone expected. What surprised me most was how quickly professional support evaporated. The HOA's attorney, who had once communicated with unwavering certainty, formally withdrew representation. The language was polite, neutral, but unmistakable. Legal counsel doesn't step away unless the risk outweighs the relationship. That withdrawal spoke louder than any accusation. Media interest followed naturally. Local outlets picked up the story, drawn by the contrast between a tiny balance and a threatened foreclosure. Journalists don't chase drama, they chase patterns. And once the settlement, the lien invalidation, and the broader fallout came together, the story stopped being about me. It became about unchecked authority. Somehow, without intending to, I became part of that conversation. I wasn't looking for a platform, but questions kept coming. How did it start? What did I learn? What would I tell other homeowners? I spoke carefully, sticking to facts, resisting the urge to personalize. This wasn't about revenge, it was about clarity. And clarity travels fast when people have been living without it. There were attempts at retaliation, subtle and predictable. Procedural delays, thinly veiled threats. But they didn't hold anymore. Once authority is exposed, repeating old tactics only confirms the problem. Each failed attempt made the situation worse for those trying to preserve control. Accountability gained momentum not because people were angry, but because they were informed. Fear thrives in isolation. It collapses when people compare notes. What Linda had built depended on silence, and silence was gone. I watched it unfold from a distance I hadn't anticipated, not satisfied, not vindicated, just aware. A system had been forced to look at itself, and it didn't like what it saw. That discomfort wasn't my responsibility to manage. Then, quietly, a document began circulating. Not an announcement, not a statement, a letter. It wasn't addressed to homeowners or regulators. It wasn't written for the media. It was short, formal, and unmistakable in its intent. Words chosen carefully to sound voluntary while acknowledging the pressure beneath them. Linda Harrington's resignation letter. The woman who had once framed the HOA as the law had stepped aside without ceremony. No apology, no explanation, just an exit time to minimize damage. But the damage had already been done, not to her position, but to the illusion of invincibility she had cultivated for years. As I read the letter, I didn't feel triumph. I felt confirmation. Confirmation that accountability works when it's pursued patiently, that power falters when it's documented, and that justice, once set in motion, rarely stops where it begins. But even as her name faded from the letterhead, I understood something important. Removal wasn't the end. It was just the beginning of consequences she could no longer control. Winning my house back was only part of the victory. When the dust finally settled, I stood in the same living room that had felt so uncertain months earlier and realized something fundamental had shifted. The walls hadn't changed. The address hadn't changed. But I had. The fear that once hovered in every corner was gone, replaced by a steadiness I hadn't felt since before the first certified letter arrived. I hadn't just defended my home. I had reclaimed my dignity. For a long time, I hadn't noticed how much of myself I'd compressed just to survive the pressure. I had measured my words, softened my instincts, second-guessed my judgment. That erosion happens quietly. You don't feel it as loss at first. You feel it as adaptation. Standing there now, I understood that the real damage hadn't been financial or legal. It had been the slow normalization of intimidation. Taking my power back meant refusing to live like that ever again. Around the community, change followed quickly once fear stopped setting the rules. Homeowners who had once stayed silent began showing up. Meetings that used to feel ceremonial became substantive. Questions were asked and answered. Proposals for reform moved from suggestion to vote. Transparency measures passed with overwhelming support, not because people suddenly became brave, but because they finally felt protected. The HOA structure itself began to change. Authority was redistributed. Oversight mechanisms were introduced. No single individual would ever again have unchecked control over enforcement actions. Records would be accessible. Notices would be documented. Power would be visible, not implied. These weren't symbolic gestures. They were structural corrections designed to outlast any one personality. What struck me most was the unity that emerged. People who had lived side by side for years without real connection began speaking openly about their experiences. They compared notes, shared concerns, realized how many of them had felt isolated under the same quiet pressure. Fear thrives on fragmentation. Once people connected, it lost its leverage entirely. At home, the difference was immediate. My wife slept through the night again. The tension that had lived behind her eyes softened. The kids stopped asking careful questions. Laughter returned. Not forced, not tentative, but real. Safety isn't just physical, it's emotional. And for the first time in a long while, our home felt like a refuge again, instead of something that needed defending. I realized then that freedom isn't the absence of conflict. It's the absence of intimidation. It's knowing that if a dispute arises, it will be addressed with fairness, not fear. That knowledge changes how you walk through your own life. It straightens your posture. It restores your voice. People thank me more than I expected. That made me uncomfortable at first. I hadn't set out to lead anything. I hadn't wanted to become an example. But I came to understand that standing up doesn't make you exceptional. It makes you visible. And visibility matters when systems depend on silence. Still, I was careful not to romanticize the outcome. This wasn't a victory story meant to inspire false confidence. The process had been exhausting. The risk had been real. Not everyone can fight this way without support. That truth matters too. The lesson isn't that power always collapses easily, it's that it collapses when it's confronted with persistence, documentation, and community. As life returned to normal, I felt something else settle in alongside relief. Responsibility. What happened shouldn't be forgotten or dismissed as a rare anomaly. Systems drift back into abuse when memories fade. That's how cycles repeat. This story doesn't end with applause or celebration. It ends with awareness, with the understanding that rights only exist when people know them, and safeguards only work when they're exercised. I didn't just take my house back. I took back my sense of agency, my belief in collective action, my refusal to live quietly under someone else's control. And while my chapter in this fight was closing, the warning had to remain. Because the moment people stop paying attention is the moment fear starts looking for its next opening. If it happened to me, it can happen to you. I'm not sharing this because my story is unique. I'm sharing it because it isn't. I didn't live recklessly. I didn't ignore warnings. I didn't break rules and hope to get away with it. I did what millions of American homeowners do every day. I trusted that the system governing my neighborhood was operating legally, reasonably, and in good faith. That assumption almost cost my family our home. HOAs hold power. Most people don't fully understand until it's aimed at them. Power that operates quietly. Power that doesn't need police or courts to start causing damage. A small balance, a disputed fee, a procedural technicality. That's all it takes to set the machinery in motion. Once it does, it doesn't rely on fairness. It relies on pressure. What I learned the hard way is that small debts can be weaponized. Not because they matter financially, but because they create leverage. Leverage becomes control when homeowners are confused, isolated, or too exhausted to fight back. The system counts on that fatigue. It counts on silence. Knowledge is the only real protection. Records matter more than promises. Paperwork matters more than tone. Authority only exists when it follows the law, not when it claims to represent it. Everything I was threatened with fell apart the moment someone actually checked the documents. Silence enables abuse. That's the part that should unsettle every homeowner. Not because you're powerless, but because power often goes unchecked simply because no one speaks at the same time. Standing up doesn't guarantee an easy outcome, but it changes the math. It forces scrutiny. It introduces accountability where fear once lived. I didn't win because I was fearless. I won because I stopped assuming the system was looking out for me and started verifying that it was. Justice doesn't arrive on its own. It requires attention, documentation, and the willingness to push back when something feels wrong. If you live under an HOA, don't wait for a crisis to understand how it operates. Read your bylaws, check your records, ask uncomfortable questions before they become urgent ones, because the next fight might already be starting somewhere else. Quietly, procedurally, invisibly. Just not at my house. If you live under an HOA, check your records, question every notice, and never assume authority means legality. Share this story with someone who needs to hear it. Protect your home. Stand your ground.